So the last time, not last week, the week before, we had finished the what I like to call the lettered rights. So when we're talking about your rights, we went through liberty, freedom of expression, access to education, even your right to a passport, your right to vote, freedom of religion. We went through all of that. And we got to the very significant place, which I just want you to pause when I read it, put some contemplation to it. And this would be the 13.3.4. It says that this chapter applies to all law and binds the legislator, the executive, and all public authorities. So when the Constitution has not written, but has within it something that speaks about the doctrine of separation of powers. And so note that the judiciary is one branch, the legislator is one branch, and the executive. And it specifically says to you that the chapter applies to all the laws made in the land. It applies and it binds the legislator, those who make law, and it binds the executive and all public authorities. Now, here's the significance on this, and I want to spend some time on it. Any law that is made by a legislator that is offensive, repugnant, fertilizer to the Constitution is void as if it never existed. So you can't just make a law not in keeping with the Constitution. You can't treat the Constitution and its sections like ordinary legislation where you just amend it on the same day without something called mature consideration. You must treat the Constitution as if when a woman carries a baby for 9 months and carry it to term and delivers it and then have to nurture it and care for it. That's how you treat the Constitution, because it is the most powerful instrument and gives power to the people. Now, the fact that it binds all law, it means that if the law is not in keeping with the Constitution, as I said, it's void. But it also binds the legislator not to make laws that would be in breach of the Constitution. And it also binds the executive, i.e. your police, what's the commissioner and the police, public authorities, right from the people who work at the tax office to the people who work at the court's office, or everybody who is a government worker, public authorities and those people, they come second to your human rights. And it literally says that the chapter applies to them when dealing with the human beings of the country. They must respect the Constitution and have in their mind the rights that are given to you, which are your rights. They have an obligation when they're even speaking to you, not to breach the Constitution, not to discriminate, not to deny you. For instance, there was an article in the paper about the dunce bags, and a principal, don't need to call his name, a principal says, oh, when you come Monday morning, you can't get into the school. You're going to be denied access to education because your parents, you as a child, your parents or whoever, somebody might have donated a bag to you. So they don't even know if just by that alone, they would have denied you access to education by not allowing you to get to your classroom because of a bag. And the thought process would seem to suggest that they paid no attention to this very critical aspect of it, which says that this chapter applies to all law and binds the legislator, the executive, and all public authorities. Now, notice the language is so exacting, because the protector of the Constitution and or what I always say is the custos morem of the Constitution, the guardian of the Constitution and the guardian of your constitutional right is the judiciary. So much so that when once upon a time, surprisingly it doesn't happen anymore, but once upon a time when something happened, there would always be a lady who, I don't know where, I didn't even know they still make slip and 90. But she would always find the camera and she would always run out and say, we want justice. Him innocent, him not do nothing. But anything happens and you hear we want justice is a call to say my constitutional rights were violated and I need protection from the court. And the judge at that point, if it's brought to their attention in any way, form, even if written on a patty bag, let me go as far as that, or if you get a hold of one of those what Rattigan called the tear-assisted fertilizer bag, and you're right that your constitutional rights were violated on that bag and submitted to the court. They're not to tell you you don't have it on the right paper. They're to read to see how best it is they can ascertain or find out what is it that you're caring about and identify it in these rights and try to give effect to it and call on the executive, the legislator, and all public authorities to say, have you breached the rights? Now that you've breached the rights, is it demonstrably justifiable in a free and democratic society to do so? Now, people might say, it sounds so pretty, demonstrably justifiable in a free and democratic society. The Constitution says that you live in a free society, and it is a democracy, which gives you the right to vote, the right to choose, and it is calling out all your powers. So the language sounds so beautiful, but it has so much meaning, because where your rights are breached, rights aren't absolute, but if the government cannot say that it is justified, then they must pay you, and they must give you damages, and they must, or the court gives you a declaration to say that the relevant, whether it be the government, the legislature, the executive, or the public authority, or even the law, has to be struck down because it has breached your rights, and you must get that remedy. Now, when one makes that assessment and understands that that is how powerful the rights are, one would see that in a constitutional amendment that is taking place, and it's not even an amendment, a new constitution is being developed, one must be worried whether or not the exact language to protect your rights will not be touched or lessened or any more or any burden, increased burden put on the average citizen to access their rights. That it should be of central concern for everybody, whether you're in the diaspora or you are here in Jamaica. These things must be the most important concern that you have, because nothing else matters if your rights are not protected as they are now within the current constitution. So again, after it speaks about the law, the rights, or the chapter applies to all the public authorities. I said it initially, but it now flows. That don't think as a citizen you have a right to be on Twitter, or you have a right to be on the Rattigan show, or you have a right to be in the social media space, or because they are foreign and then can't touch you, you're just there violating people's rights by use of your freedom of expression. You have to be careful with that, because, and our very erudite Chief Justice has interpreted that the very right these rights may apply horizontally, as in citizen to citizen, because section 5 or subsection 5 says that a provision of this chapter binds natural or juristic persons, as in even a company, if and to the extent that it is applicable, taking account of the nature of the right and the nature of any duty imposed by the right. So the nature of the right, what does that mean? I need to explain it to you. If my right to life is affected by your right to run your mouth, i.e. your freedom of expression, boy, you may very well get thumping in your mouth and the court say that I don't violate your right. I'm just trying to be as very practical. Similarly, if I have my right to freedom of expression and the case Tomlinson and those networks, whether it be TVJ, CVM, all of them, even PBC, I think he sued everybody. Maurice Tomlinson, he wanted to use his ability of freedom of expression to disseminate information on the private platforms, being private ownership. The broadcasting stations were private, and they said no, and they didn't give him airtime, and he sued. And that's where the court says, well, you do have the right to sue horizontally. So he was correct to say that. But your right to freedom of expression does not trump my property rights. So it speaks about you take into account the nature of the right and the nature of any duty imposed by that right. And so if I have property right, I have a right to say, I don't want you to use my platform. So Ratican can say, listen, right now, I'm exercising my right, my property right, my broadcasting ability, my platform to censor Isat because I don't like what he's saying. And I can't say, hey, Ratigan, bring me on your show next week. I'm a freedom of expression. You're fighting against the Rastaman. Because practically, he has his right to protect his platform, protect his space from how you are disseminating information. And so horizontally, we look at it. Ironically, in the United States, these same rights have been challenged, and state by state, I take up the newspaper or watch on the news from time to time how these rights are balanced, i.e., a woman has a ma and pa cake factory, and she says, oh, I'm not baking cake for you people. And they take to court, and the court says, listen, you should bake the cake. You are discriminating, and we order you that damages because you never gave them a service. Other people says, no, it's their business and it's privately owned. They don't have to. And so the states are divided in terms of how to balance rights horizontally. And then their laws that we spoke about all laws, are a little bit different from state to state. In the Jamaican space, I think we are still lagging behind in terms of legislating laws that are practical and make sense. And so it's not until something comes up to the forefront and challenging the court that we see how far behind we are. And in the interest of justice, sometimes I just wish that when the state is challenged, rather than trying to defend the indefensible or defenseless, it takes a bigger government to say, aha, you caught us, but we're going to correct the wrong immediately, because that's really what it is about. Because I promise you this, taxpayers don't win when the state is sued, and the citizen is victorious in a lawsuit. It is the people of the country that will suffer, because it's not, if the minister does something, it's not the minister's pocket it coming out of, it's the taxpayers' money. If the public authority does something, you're not suing the public authority. The commissioner does something and you don't like it, and you sue him, you're not suing him in his private capacity. So it's not a ha-ha moment, and nobody wins. And so we have to have respect for the Constitution, be cognizant of our rights, and even as citizens, when we use our platform, we always think of minority rights and understand that, hey, come for the Rastas last week, they may very well come for the short people next week. They may come for the dark-skinned people. They may come from the light-skinned. They may come for the fat people. And it is just today for you, tomorrow for me. And minority groups, we all fall into minority groups by virtue of being a human. So like Ratigan and Andre used to always tease me on the Andre show about being big nose. And they used to say, so I fall into the big nose people. So every time I hear them say they don't like the big nose one, I say, boy, look how they fight against me. I'm a prime minister. But anyway, so moving on from that. So at 6, it says no person shall be subjected to torture or inhuman or degrading punishment or other treatment. Here's the thing, and the Constitution, I got in trouble the last time I said something like this, but the Constitution is written as if Shakespeare, who wrote the Bible, the King James Version of the Bible, wrote the Constitution. It flows in literature, in sequence. It has everything necessary to alert you into what it is to feel like a human being, what it is to be reminded to be assertive that even if you wake up and you're dirt poor and you want to be worthless and rub out your hand middle and wear a dunce bag and you just want to live like a vagrant. That's why they made laws for vagrancy laws for people who didn't want to work because they didn't want to continue to be slaves. Well, the Constitution says it. No person shall be subjected to torture or inhuman or degrading punishment or other treatment. So much so that where someone forfeits their freedom, they have not forfeit their other rights. Takes us to the conversation that Ratigan just led us through as to why it is his internet wife would reject a state-of-the-art prison when common sense can tell you. And oh yeah, I'm back. What was it called, Herb? The math you call it?
Voodoo.
Yeah. Voodoo math. Yeah. It must be voodoo math because here we're a third world country. Certainly, if Ratigan telling friend them to give me a prison, I'm gonna take the prison, and we in the Caribbean have something called sunset legislation. So you give me 30 prisoners, some of them did shoplifting, whatever. You take the prisoner, you do sunset legislation, and you give them a second opportunity. You put them out on probation, and you use the facility to advance your security system by putting the maximum people in that state-of-the-art prison and continue to fix the prison to make the standards important for bringing up human treatment, non-degrading punishment, or any other treatment so that people like Isat can come up and fix your prison, it's dirty and it's this and it's not in keeping with the Mandela standard, because we are in 2023. It has to be a thing that we're still celebrating roads which we were always supposed to have, which was always in motion, while people don't have homes, and then you're locking up people in droves and putting them into systems where it looks like not even kennels, because the veterinarians have animal. Peter would certainly condemn them for treating animals the way humans are treated here. So again, the Constitution reminds you that even where you have done some wrong, you shall not be subjected to torture or inhuman or degrading punishment. And so these are where, even when you sit as a judge and you're considering the time you're sending somebody into prison, one must consider, but what are the conditions, and should I send them? Will that correct the wrong? Is this the type of punishment? And when I speak of hard labor, is it supposed to be that I put you in a pit to serve your sentence? That's not hard labor, that's just hard treatment. Now, at 7, it says, nothing contained in or done under the authority of any law shall be held to be inconsistent with or in contravention of subsection 6, to the extent that the law in question authorizes the infliction of any description of punishment which was lawful in Jamaica immediately before the commencement of the Charter of Fundamental Rights and Freedoms, Constitutional Amendment, Act 2011. Now, this section simply is what the government uses to say, well, so we get the prison, so we keep it, and therefore we are a work in progress. See with us, we'll get to it where we get it. But as it's a matter for the people to say whether or not in a free and democratic society, we should allow certain things to go on. And this is conversations from the Constitution. It is conversations about human rights. And notice that the Constitution, the Charter, contemplates even for persons incarcerated. So when it speaks about the execution of a sentence of death imposed after the commencement of the Charter of Fundamental Rights and Freedoms Act on any of persons or any offense against the law of Jamaica shall not be held to be inconsistent with or in contravention of this section by reason of, and this section is about the response of the government to what was the Pratt and Morgan situation. So our highest court, the Privy Council, would have said it was cruel and inhumane punishment to keep people on death row for more than 5 years without them knowing when they were going to be sentenced to death or whether they had an appeal pending. And persons were just languishing on death row, and that changed. The Privy Council said it was inhumane, and then we came back with our charter and said, listen, our system not perfect. If you're there and you're sitting on death row, you're just going to be on death row. The thing about it is that the judiciary, in all their wisdom, they don't sentence people to death anymore, even though it's on the law, and they don't even contemplate it by virtue of the sentencing guidelines, even though we have it on our books. So when our politicians is saying, "Oh, we need to bring back the death penalty, and crime is this and this," the Privy Council says death penalty is for the worst of the worst, and the crimes that I see happen in Jamaica. You see me stuttering because sometimes, my God, you see the crimes, and it seems like every day these people find ways to be more Uncle Demon and Auntie Demon than the people last week when you watch the news. That's our reality here. And I think the worst of the worst takes place every day. But if you are a human rights advocate, I don't think that I think it's very inhumane for judges to sit and look you in your face and say that you forfeit your right to live among us and forfeit your right to even live at all. When you hear it, when you hear those words, if you have any humanity in you outside of emotion, you would not want to speak those words, because it's not words. Those are words of God. It should never be repeated as of man. That's just my position. And the Constitution says you have your right to think otherwise as to the death penalty. The thing about it is, we are a third world country, and the United Nations, Amnesty International, they take a certain position. They would be sanctioned if we were to carry out death penalty. So I'm never worried about it. 1988 was the last time, and we are 5 years away from it being 40 years. Yeah, so God's willing, we will fix our crime problem and won't ever have to think about executing people. So that's the Section 8 aspect of it. Again, nothing contained in or done under the authority of any law shall be held to be inconsistent with or in contravention of subsection 3F. And 3F, as you know it, was the right to freedom of movement. That is to say, the right of every citizen of Jamaica. So that 3F of this section and sections 14 and 16.3, which is the due process aspect, to the extent that the law authorizes the taking in relation to persons detained or whose freedom of movement has been restricted by virtue of that law, of measures that are reasonably justifiable for the purpose of dealing with the situation that exists during a period of public emergency or public disaster. I hope you're listening, because you don't have to be a criminal for your freedom of movement or for detention to happen to you. One of the biggest fights with the state of emergency is, and why the government and the private sector and certain sectors of society would have preferred the state of emergency, is it cancels your rights. It cancels your authority, to your ability to say, listen, you're violating my rights. When there's a state of emergency, you lose your right to privacy. All that is in your cell phone, they can just get in there and they can just look and they can violate you. Your family life is torn apart, and you lose your humanity by virtues of state of emergencies. And when state of emergency, not only in the sense of how this government had used it, but also if there's a hurricane tomorrow or a COVID, we're not going to talk about COVID, but natural disasters, if those things take place again, you can see how these rights are suspended, and the Constitution pretty much contemplates it when it's done in a real way and legitimate way. And that's why it speaks of for the purpose reasonably justifiable, which is to me a higher standard of demonstrably justifiable. Reasonable justifiable for the purpose of dealing with the situation, because these situations are thought to be temporary. Nobody contemplates that when you're going to be detained, it's going to be for some long ended period. Because I can tell you that a day in detention is like 1,000 years. The Bible speaks about it, 1,000 years in thy sight, and if by reason of strength and stuff like that. So, yeah, that's that on that aspect of it. We get into subsection 10. it speaks about a person who is detained or whose freedom of movement has been restricted only by virtue only of a law referred to in subsection 9, that's the state of emergency, public emergency laws, may request a review of his case at any time during the period of detention or restriction. But any request subsequent to the initial request shall not be made earlier than 6 weeks after he last made such a request. And if he makes such a request, his case shall be reviewed promptly by an independent and impartial tribunal, which shall be immediately established pursuant to law and presided over by a person appointed by the Chief Justice of Jamaica from among persons qualified to be appointed as a judge of the Supreme Court. So, again, even when you are detained, you have a right to challenge your detention, and the persons who are to do it are the competent authority. And you see how much power the guardian of the Constitution, the custos moral of the Constitution, is given. So do not take. Sometimes I say people curse the Chief Justice, and it's cute, it's laughable, it's peculiar, but recognize how much power the Chief Justice has, because he is the guardian of the Constitution. And likewise, the judges of the Supreme Court, the Judiciary, are the protectors of the Constitution. And so they are the competent persons to decide who will review you. And if he appoints somebody, he is saying, this is somebody with the competence of a Supreme Court judge. And if they review it, then it may very well be that if they say you're to stay, that's powers exercised by a competent authority. What would take place in the state of emergency was a little bit different, and that's the drama behind the whole review board for the detention. So on any review by a tribunal in pursuance of subsection 10 of the case of any person who is detained or whose freedom of movement has been restricted, the tribunal may give directions to the authority by whom such detention or restriction was ordered concerning the continued detention or restriction of movement of the person, and the authority shall act in accordance with such directions. Now, having heard all of that, I just wanted to understand that the Constitution itself makes provisions for how to detain persons. So when people just use detention as a crime-fighting tool and is using the tool outside of the Constitution, one has to wonder under what authority would that come up, and why the public is to be concerned that in a situation where the Constitution sets out clearly the parameters of the use of a tool like that, why was it not taken in accordance with the Constitution? That's something to think about in terms of your protecting all the rights we spoke about earlier. Well, this is what we call the Saving Laws Clause, and it is before the court now. There is a case challenging whether or not this Saving Laws Clause has any value. It reads like this: nothing contained in or done under the authority of any law in force immediately before the commencement of the Charter of Fundamental Rights and Freedoms, Constitutional Amendment Act of 2011, relating to sexual offenses, obscene publications, or offenses regarding the life of the unborn child, shall be held to be inconsistent with or in contravention of the provisions of this chapter. So what has happened here is that the Charter amending the Constitution has only saved laws in existence in relation to sexual offenses, obscene publications, and offenses regarding the life of the unborn. So it puts into question whether laws which are on the books that are offensive to the Constitution are still has force. I won't get into the conversation of which laws, but I know one can think of some of them. But I want to leave the OBIA Act alone. We are in times of peril, and if you have to guard up and take a trip to St. Thomas, you should have the freedom to do so. And in any event, they're not prosecuting anybody for OBIA, but I'm going to leave it right there. So with that one. Now, in subsection 13, it speaks of public educational institution, and it means an all-age school, a pre-primary school, or a primary school that is maintained or assisted by the government. And so when it deals with education the right to access to education stops at the primary level. So with a constitutional amendment, in my view, especially when we're talking about Herbie saying maths in our time and certainly maths in my time and what we're dealing with, and the voodoo maths that taking place at RADA, and the lack of accountability of at least 500 portable assisted bags from Morocco, one can understand that we probably would want to increase the access to education right up to the tertiary level. I believe that education should be free right up to the tertiary level, even if you don't want it. And I guarantee you this, even when it's free, enough people not going to use it anyway. But the government should have the duty, it should be an obligation on the government to ensure that right up there. So when people open their mouth and you want to cuss the government response, ideally in such a small society, would be listen, I know my fault, so you don't, you know, we are paying for to go get on the education right up to tertiary level. Why are we lagging? Why do I need to import workers when you can go take your book, pressure your book? That's the kind of conversations, and that's what we should be looking to, and that's what we should be trying to struggle with. But that's just my utopian voodoo assessment of the Constitution. So I hope I'm not boring you, because this is exciting for me, but you need to tell me when it gets overwhelming. I want to touch on this particular chapter because it speaks about protection of freedom of the person, which is so important, because in the Jamaican space, it is literally it's violated. And I think that when you hear the conversations, persons don't understand. So when you hear like a Jamaican for Justice speak out, or stand up for Jamaica, or even me in the human rights space talking about human rights, people say, oh, we not talk up for the criminal them, or we not talk up for them people, and them people are no good. But it is the Constitution that empowers that type of advocacy and an appreciation of of not stripping people of humanity. I think would change the conversation, and it certainly would put a lot more pressure on leaders in terms of what their policies are when they don't include the citizen, the ordinary man. And so that's when you think of protection of freedom of the person, just understand how important it is to wake up every morning and be free, like an individual, disconnected from everybody else. Whether you're married, whether you are a government worker, whether you're self-employed or not, but the need to feel that you have the freedom of the person. That's what I'm trying to get at. So no person shall be deprived of his liberty except on reasonable grounds and in accordance with fair procedures established by law in the following circumstances. So it sets it out. And I'm going to preamble the conversation to say that not picking on anybody, but we've seen where we speak about the two Jamaicas. If a poor person is suspected of a crime, your name is called, your face is sometimes published. They tell them who your address, them tell you who your mother is, them tell you, although your daddy ain't your daddy, and now you know him's not your father, and everything comes out about you, and you're suspected of the crime. And they say, come turn yourself in at the police station, and if you need bus fare, we will give it to you, but come do some time while we investigate the matter. Versus like a former minister of education who is suspected, and then they don't lock him up, they investigate and they do everything to ensure, and then he's not put in the prison system. He's shielded from that because it's done right for him. Or just like how we still haven't heard the name of the 6 people that could be suspected of the unjust enrichment or something like that, because the law is working for them. That's how the law is supposed to work, and it's supposed to work for you. And your liberty is not supposed to, you're not supposed to be stripped of your liberty or put in places unless it's reasonable grounds and in accordance with fair procedures. So those are the procedures that I'm talking about, established by law. And here are the circumstances. In consequence of his unfitness to plead to a criminal charge. So if you're a using the term loosely, if your head not good, or you're mad, or you don't have the sense enough to instruct your attorney, you're not fit to say guilty or not guilty, the law actually says they're supposed to send you to Bellevue, but they don't do that. Unfortunately, we send you to one of the old prisons because Rattigan internet wife decided not to take a new prison. Remember that. And as a result, there are persons who were arrested in 1970 that even now is languishing in prison, and we probably don't know. Similarly, right through, there's somebody's brother or son was arrested in 1990, and he's still in prison now because we don't know his name, and he's not fit to plead, and he's lost in the system. In the execution of the sentence or order of a court, whether in Jamaica or elsewhere, in respect of a criminal offense of which he has been convicted. In execution of an order of the Supreme Court or of the Court of Appeal or such other court as may be prescribed by Parliament on the grounds of his contempt of any such court or of another court of tribunal. And in execution of the order of a court made in order to secure the fulfillment of any obligation imposed on him by law, for the purpose of bringing him before a court in execution of the order of the court, i.e. arrest warrant, execution of a summons, and the arrest and detention of a person. And it says, for the purpose of bringing him before the competent legal authority on reasonable suspicion of his having committed an offense, or where it is reasonably necessary to prevent him from committing an offense. And in the case of a person who has not attained the age of 18 years for the purpose of his care and protection. Now, the detention of a person for the prevention of the spreading of an infectious or contagious disease constituting a serious threat to public health. You can think of the COVID, monkeypox, all of these, dengue, whatever, anything that's communicable that can spread, the health authorities may have to contain you. Suffering from mental disorder or addicted to drugs or alcohol where necessary for his care or treatment or for the prevention of harm to himself or others. Just notice as I'm reading this, the Constitution has contemplated all the possible circumstances of which they would have to strip you of your liberty. So the arrest or detention of a person who is not a citizen of Jamaica to prevent his unauthorized entry into Jamaica. Think of the Haitians who were sent back, and whether it was done fairly is a question, but what the Constitution contemplates is what is important, not the court of public opinion. And against whom an action is being taken with a view to deportation or extradition or other lawful removal or the taking of proceedings related thereto. Now, moving on from that, it says any person who is arrested or detained shall have the right to communicate with and be visited by his spouse, partner, or family member, religious counselor, and a medical practitioner of his choice. And at the time of his arrest or detention, or as soon as it's reasonably practicable, to be informed in a language which he understands of the reasons for his arrest or detention. And where he is charged with an offense, to be informed forthwith in a language which he understands of the nature of the charge. And D, to communicate with and retain an attorney at law. And any person who is arrested or detained shall be entitled to be tried within a reasonable time and shall be brought forthwith as soon as is reasonably practicable before an officer authorized by law or a court, and released either unconditionally or upon reasonable conditions to secure his attendance at the trial or at any stage of the proceedings. This is the Constitution telling you that you actually have a right to bail. And it is unfortunate sometimes that we always are advocates for persons who commit crimes not to be given bail. But there should be an appreciation that bail is for the purpose of you attending court, because you are cloaked in the presumption of innocence. And I know I don't even have to read the content, the comments, because this is the part where I always get all of the bashing saying, yeah, if a man commit murder, why he must get bail and murder them for stay and blah, blah, blah. But just remember that it's evidence in court that is important, and that is not until you're convicted of what you're accused of that people can legitimately start to put or judge you for that crime after your trial. And so bail remains as of right, and if a person is able to come to court and the judge is assured that he's not going to harm himself, harm people, tamper with the witnesses, he should have his right to bail. Now, if he's not released as mentioned in paragraph A2, he shall be promptly brought before a court which may thereupon release him as provided in that paragraph. And now, any person awaiting trial and detained in custody shall be entitled to bail on reasonable conditions unless sufficient cause is shown for keeping him in custody. And so there's always the conversations about you're going to tamper with witness and everything that I said earlier. But the aspect of it is that what the Constitution contemplates is that bail is as of right. What is being advocated is that violence contributors, not a legal term, but a term coined by Uptown to label people the poorer class, so it sounds good, so that they can detain you and so that they can criminalize you, is not a sufficient reason to deprive you of your liberty. This is just me trying to demonstrate to you how the Constitution respects freedom of the person and the importance of your liberty, and that it shouldn't be taken lightly, and no one should feel that even where you're suspected of a crime, that you should lose your liberty. Your restricted movement should come from bail, and especially where our criminal justice system doesn't march along as fast as it should. And certainly prosecutors and police officers shouldn't get the opportunity to simply tell a judge that you will tamper with witnesses and that you're a bad guy and we have the evidence, when they really don't have the evidence, and then you lose 6 months of your life and nothing comes of that. And then it's not guilty. And there are persons, it was in the paper just recently, a man spent 5 years before he was brought to trial, and at some point, 3 years into it happening, the prosecution would have known that they never had the witnesses and he stayed there. Now he has his lawyer suing for it, but you'll never get back that 5 years. He just sat there 5 years and nothing. You lost your liberty, you lost your opportunity. I can tell you, it takes 5 years to become a lawyer. I think 5 years is a lot of time to just be languishing in detention, and nobody steps up and say that something is fundamentally wrong with that type of detention. And we should rethink, especially when we can monetize the bail system, where persons commit crime and you pay what you need to pay to be out on bail and be monitored. And we try to use technology to bring people in the system to regularize our system and make money. But instead, we're denying bail when the government could be getting straight up bail money and bail bondsmen and creating opportunities for the sector. Since crime is so high in our country, we should try to formalize it in a way that the country makes money. That's my take on that. So any person deprived of his liberty shall be treated humanely and with respect for the inherent dignity of the person. Very important, as it says, even where you lose your liberty, you do not lose your humanity. You should be treated humanely and with respect for the inherent dignity of the person. So the question we should ask ourselves is that as we deprive persons of their liberty, should we have the right to deprive them of their liberty with the dog kennels that we have as prisons in Jamaica? I can't be more graphic than that, and this is the best way I can behave myself. I'm passionate about that aspect of it, but we need to fix the prisons before we strip people of their humanity, and we are actually creating a breeding ground for criminals. So a man who committed perennial larceny, who sits in prison with actual convicted murderers, share the same cell with them, and when he leaves, he is completely birds of a feather, if you want to say they flock together. When you interact with people, you become them or they become you. That is just a part of human nature. And so we have to think about that in terms of classification of prisons and how we put children in harm's way. A man who become a thief is put into a breeding ground to become a murderer, and then we say it is the family that is the problem. But you put them in situation. You put somebody who has never committed a crime into detention in the conditions that they are placed in, their heart become hardened, they're stripped of their humanity, and they're open to do anything. So that's where we've done liberty up to now, and I think next week I'll go through property, because it's heavy stuff, and I'll leave the floor open for questions or anything. Thank you.
The informative information presented in this video is motivational and is positively aimed at inspiring, educating and entertaining the viewers with the cutting edge of critical reasoning. If you enjoy the contents on the Black Radar YouTube channel, Please consider subscribing to show your support.